Welcome to Habeas Humor, where we explore the lighter side of the law. We're going to get right into it today. My name is Sharon. I am an attorney in the U.S. with 3 years of experience. I don't want to say the number of years. I'll just tell you it's more than 10. This episode, we introduce a new segment called YouTube Reviewed with a Tude.
I'm smart, you're dumb. I'm big, you're little. I'm right, you're wrong.
This is where I perform sort of a legal accuracy check on a video by another YouTuber. And while I'm doing that, I cop a tude, like per normal. That's pretty much normal for me. Are you a gamer? Me neither. Not in the proper sense. My partner has a game station, and my favorite game is Cat Lateral Damage. That's where you, it's like a first-person, what's the equivalent of shooting if you're a cat? It's not a first-person shooter. It's a first-person cat messing things up game. So you like knock plates off the shelves, books and plates and glasses. You just mess everything up in the house. There needs to be more levels for that game because there's only like 4 or 5. If Cat Lateral Damage guy is watching, please make more levels. Anyway, I do also play games on my phone, and as it turns out, according to something I read one time, mobile games are huge with women, as if you didn't know. I'm one of the few mobile gamers who is able to say that I have never once played the Quasi Cupcakes or Candy Crush saga. That never appealed to me, mainly because it looked like a rehash of Bejeweled, which I used to play all the time on Yahoo Games, and which I was completely over by the time that Candy Crush came out. God, I had pulled so many all-nighters playing Bejeweled and Alchemist, whatever it was. Any game like swapping shapes between columns was like triggering to me by that point. I'm like, no more. So of course, in using these mobile gaming apps, I get shown plenty of advertisements, and chances are you know exactly what I am talking about. Have you ever been enticed into downloading the game only to discover that's not even the same kind of game that was advertised? We definitely are living in a post-truth world. Why does this game deception happen, and how are game advertisers managing to skirt truth in advertising laws? These questions are tackled in the first YouTube video that we will be reviewing for this series. It is titled, Game Theory, Are Your Mobile Games Illegal? And it is by a channel called The Game Theorists. Let's take a look at the video and see whether the game theorists know what they're talking about, legally speaking.
If you've spent a lot of time using the mobile version of YouTube, you've probably seen mobile game ads like this. And this.
My father is the chief of Navy.
Take him.
And this. Ads that are not only ridiculous, but also totally misleading as to the actual contents of the game. But if you were drawn in by the promise of some simple logic puzzle game and actually downloaded the thing, what you would get wouldn't be a quality gaming experience, it would be quite a surprise. Here's the ad, here's the actual game. It's tile matching with town building elements. Absolutely nothing like what the ad promises. The only bad dream I need to make sense of today is how any of this is legal. Why do mobile game companies do this? Or maybe the better question, how are mobile game companies able to do this? Like, shouldn't this kind of misleading advertising be illegal? What is really going on here with these ads? And why isn't anybody doing anything to stop it?
All right, they start off by asking the questions, shouldn't these misleading ads be illegal, and why isn't anyone doing anything to stop it? These are good questions, however, they are also loaded questions because they contain factual claims. Asking whether these misleading ads should be illegal assumes that the ads are misleading, and asking why isn't anyone doing anything to stop it assumes that no one currently is doing anything to stop it. Let's keep watching and see if the factual claims in those questions are true and if the questions get answered.
Let's take a look at the landscape from the last couple years. Misleading mobile game ads come in a lot of forms. In its laziest form, it just straight up takes gameplay footage from an entirely different game to pass itself off as something that it's not. Take, for example, the game New Mobile Game, You Can Do Whatever You Want. And yes, that is literally the name of the game. Anyway, if you pay attention for more than 2 seconds to this game's trailer, you'll probably notice that, despite the fact that it's purporting to be an ad for a mobile game, the gameplay footage has a mouse cursor in it. That's because the footage was taken from a city builder game for the PC called Banished, which, by the way, is an incredibly relaxing way to spend time if you're cooped up indoors and long to answer the call of the wild by creating a colony out in the wilderness. But apparently one of the things that you can do in New Mobile Game, You Can Do Whatever You Want, includes very obviously stealing the footage of one game to promote something completely different. But then we get to the next tier, galaxy brain status. Rather than copying someone else's homework, they've taken to creating entirely new ads that don't resemble existing games, including the game that they're advertising. These are your pull the key ads, or steal the loot, or give the suffering people a very obvious solution to their plight ads. And it's nothing like the game that they're tricking you into downloading.
This is quite interesting. Before watching the Game Theorists video, I never knew that stealing footage from one game to advertise another game was a thing. I always presumed that the animation shown in a game ad is either footage from the game itself or like additional animation that's made for the commercial to enhance the commercial. I have certainly downloaded games based on advertisements and then found that they were different than shown, but I never actually picked up on the fact that the footage was in the ad was from a different game. As it turns out though, mobile game ads will sometimes simply show gameplay footage from a whole other game. Now, if you take game art from a different video game that you don't own the rights to and you put it in your own commercial, that is not lawful. For one thing, using images created by someone else is a copyright violation unless you have a license to use it or unless your use falls under the fair use exceptions. A product commercial is not a fair use exception, so if you are using game art that you don't own for a commercial, you need a license. The word license as a legal term more or less means permission. If I want to make a commercial and use art from a video game I don't own, I need permission from the owner of the art. And generally, I will not get permission without giving money for the use of the art, which is fair. The purpose of a game commercial is to sell a game and make money. So if you use someone else's work in your commercial as a tool to make yourself money, you should pay for that work. Now, what if the owner of a game with footage that you want to use in your commercial doesn't want it used in a commercial for another game, no matter how much money is offered? Can they refuse to grant a license? Yes. That is their right, and they might have very good reasons for not wanting their art to be associated with the other product. In the Game Theorist video, they use the example of a game that is interestingly called New Mobile Game, You Can Do Whatever You Want. I'm going to just call that game by its initials, NMGYCDWYW. Actually, you know what? Just NMG. It's pointed out that the ad for NMG contains game footage that is actually from another game, a PC game called Banished. You may be wondering if the art from Banished that is shown in this ad is being used illegally. The short answer is, I don't know. It depends on some things. First, do the owners of NMG also happen to own the rights to Banished? Possibly, but I doubt it, since Banished is apparently an indie game that is created by a company called Shining Rock Software, and Shining Rock Software appears to be a one-person company. So assuming that NMG does not own Banished, we would need to know if NMG properly obtained a license to use the game footage from Banished. Unfortunately, there is no way to know that without interviewing the people involved. I hope that NMG's use of Banished was properly licensed. Maybe, and this is pure speculation, NMG tried to license Banished, but Shining Rock Software said no. Why might they say no? The most likely reason is that Shining Rock Software does not want their game Banished to be associated with some slapshod mobile game. What if members of the public downloaded NMG, expecting it to resemble Banished, only to discover, to their disappointment and horror, that it's nothing at all like Banished? People might blame Shining Rock Software for the shitty quality of NMG, not realizing that Shining Rock Software actually had nothing to do with creating NMG. People might think that Shining Rock Software's quality has just fallen off a cliff and they won't buy games that Shining Rock may put out in the future. Or people might think that Shining Rock Software actively played a knowing part in this advertising deception, which, come to think of it, would be true if Shining Rock did allow artwork from Banished to be used to advertise NMG. NMG is reminding me of MSG. Shout out to Uncle Roger. Anyway, I can totally see a game designer not wanting any part of this mess and therefore telling NMG, nay, I shall not grant you a license to use gameplay footage from my game Banished to advertise your dastardly mobile game. Good day, sirs. I said good day. Since there are no credits in the ad for NMG, we cannot know whether the footage from Banished was used with permission or was simply stolen. If it was stolen, then I hope Shining Rock Software goes after NMG to enforce their legal rights. It's possible that NMG took a gamble and used the art from Banished without permission, hoping Shining Rock would be none the wiser or that Shining Rock would not have the will or the resources to sue. I'm not saying that this happened, I am simply saying it might have happened. If it did happen, I hope Shining Rock takes NMG to the cleaners. So that is the copyright issue that comes into play when an advertisement for a game uses images from someone else's game. There is another legal issue, possibly even more important, and that is the misleadingness of airing a commercial for a game where the visuals shown are from the wrong game. Whatever happened to truth in advertising? Maybe the game theorists will address that. Let's see.
This can't be legal, right? Advertising a completely different product than the one you're selling. Whatever happened to truth in advertising?
Oh, good.
Well, if you want to know the answer to that question, just ask the FTC, the Federal Trade Commission, who you might also know as the governing body responsible for rules around disclosing sponsorships for influencers. According to the FTC website, quote, when consumers see or hear an advertisement, whether it's on the internet, radio, or television, or anywhere else, federal law says that ad must be truthful, not misleading.
Did the game theorists get this part legally right? Yes and no. They focus on the FTC, the Federal Trade Commission, which is not to be confused with the FCC, which won't let me be or let me be me, so let me see. The game theorists in their video talk in terms of FTC policy when they are discussing advertising law. This is because if you Google false advertising law, your top results will all take you to the FTC website, which provides information about advertising rules as shown in the game theorist's video. Technically, it is true that in general terms, the policy of the FTC is that misleading ads are not allowed in the US. The thing is, the FTC does not make the rules, at least not that rule. Congress made that rule. Federal agencies such as the FTC and others do make rules, which usually go by the formal label regulations. For example, you know how it's illegal to tamper with the smoke detector in an airplane bathroom? The US Congress did not write that law. It's a regulation created by the FAA, the Federal Aviation Administration. The federal truth in advertising laws, however, are statutes that are enacted by Congress and codified in the United States Code. The particular part of the United States Code that addresses false advertising is known as the Federal Trade Commission Act. As the name implies, that section of the law is how the FTC agency was created. Federal agencies are part of the executive branch of the government, which means that they answer to the U.S. President. However, the agencies are created by acts of Congress. The Federal Trade Commission was created in 1914 when President Woodrow Wilson signed the Federal Trade Commission Act into law. You can find that law in the United States Code at Title 15, Section 41. According to Title 15 of the Code, Congress established the FTC to regulate various aspects of commercial trade in the U.S., and if you look at the text of Title 15, Sections 52 through 55, you will see that Congress wrote explicit laws that make it illegal to disseminate false advertisements. The law also says that the FTC is empowered to take action against false advertisers, and that under federal law, false advertising is a misdemeanor that carries a punishment of up to 6 months imprisonment or a fine of up to $5,000 for the first offense. You could be forgiven for taking this to mean that the FTC prosecutes people criminally, but that is not the case. Theoretically, the FTC could probably have its attorneys prosecute criminal cases in federal court under this act, but in the federal system, it is pretty well established that the Department of Justice is the agency that prosecutes criminal cases. And on the FTC's website, they clarify that criminal matters in the FTC are dealt with by referral to the DOJ. The DOJ's prosecutory power is already established, and it doesn't need to be written into every act that makes something a crime. The FTC, on the other hand, does not have any established power other than what's given to it in this act. So it can only do the things that Congress has written down here. In the FTC Act, Congress gives the FTC the authority to take action against false advertisers. However, since the FTC was created as an agency in the U.S. Department of Commerce, they really are not built to deal with crimes. So they are the separate but equally important agency that deals with civil matters of regulating trade. Kakunk. And the most they do to offenders is impose a civil fine. Moving on to the definition of false advertisement. This is in the United States Code at Title 15, Section 55. At subsection A1, it says that false advertisement means an advertisement other than labeling, which is misleading in a material respect. In a material respect basically means in a way that matters. That is purposefully broad language because the members of Congress don't want to get bogged down by details. They got fundraising calls to make to their donors, so they go, here's the law, don't do false advertising. Further interpretation will be left to the FTC and the courts. Now when's lunch? That being said, there is one thing that Congress was loath to abandon to the winds of chance. If we scroll down to Section 55A2, we will see a rather specific provision about margarine. Disgusting margarine, or as it is known formally, disgusting oleomargarine. Let me dispel any rumors about margarine here and now. Everyone can, with zero difficulty, believe it is not butter. And any lying advertisers trying to claim otherwise better watch their step. Section 55A2 says that an advertisement for any kind of margarine shall be considered per se misleading if, quote, representations are made or suggested by statement, word,
better,
grade, designation, design, device, symbol, sound, or any combination thereof,
better,
that such oleomargarine or margarine is a dairy product, end quote. Who the hell got that put in the federal law? If you guessed big butter, congratulations, you are correct. Yeah, it turns out that margarine regulation in the US has been a major deal in food law pretty much ever since margarine placed its first oily blotch on the stage of US food trade. According to Wikipedia, margarine was first invented in France in the year 1869. Yes, France, home of the cordon bleu. Not your Muriel, mes amis. My French is terrible. The demand for the product came from Napoleon, who wanted to be able to feed his soldiers a non-dairy butter substitute. In 1871, Henry Bradley of Binghamton, New York, of course, Binghamton, New York, patented a process to create margarine by blending vegetable oils with animal fats.
Yummy!
During the next 15 years, margarine took off in the US. It was cheaper than butter and probably more shelf-stable, so who cares what it tastes like, I guess? I can't be mad at the people from back then that bought it. I mean, those were hard times. Here's the thing, though. Sales of butter went down when margarine came on the market. And you know that's going to give the dairy industry a case of mad cow disease. They lobbied the government, but it being the golden era of laissez-faire capitalism, the government was like, sorry, big butter, market forces are market forces. We can't regulate the economy. That's the job of the invisible hand. Haha, just kidding. That rule is only for market forces that hurt poor people. Congress passed the Oleomargarine Act of 1886, which imposed an extra tax on margarine at the rate of 2 cents per pound. Certain members of Congress were more in favor of this than others. Representative William Price of Wisconsin, cheesehead, compared margarine to counterfeit money, saying that if he could have his way, quote, "Oh, you betcha." Actually, that part wasn't recorded as part of the quote, but probably that's how he started. He then said, quote, "I would make the tax so high that the operation of the law would utterly destroy the manufacture of all counterfeit butter and cheese, as I would destroy the manufacture of counterfeit coin or currency. Oh, you betcha." Hey, I don't like margarine either, but I wouldn't go as far as saying it should be treated as illegal contraband. There were also parallel state laws passed around the same time, so in many parts of the US, there was just a wild amount of tax on margarine. The aforementioned Federal Oleomargarine Act was on the books from 1886 all the way until 1950, when it was replaced by more benign statutes that just regulated the manufacture and labeling, and as we saw, the advertising of margarine. The advertising law that I previously read to you, prohibiting the misrepresentation of margarine as a dairy product, was put into the United States Code in 1950 as part of that whole sweeping reform of margarine regulation. What does margarine have to do with video games? Nothing yet, but I do have an idea for a mobile game called Margarine Man. You'll play a character shaped like a stick of margarine, and the object will be to go around and rub your animal tallow-based slop on people's food before the enemy buttermen can beat you to it. If any game developers are interested, get in touch. You heard that, Shining Rock Software? So, to recap the essence of what we just read, Congress put a law on the books saying false advertising is illegal. Congress also created the Federal Trade Commission to carry out the enforcement of advertising law, and we will get to more detail on that in a bit.
Now the bad news, or more importantly, the loophole. Enforcing these rules
Oh, I guess we're getting to that right now.
Enforcing these rules for misleading mobile game ads is probably not very high on their list. Again, from the same FTC info page, quote, "The FTC looks especially closely at advertising claims that can affect consumers' health or their pocketbooks."
They pulled that directly from the FTC website, which is good. However, the website is vague about what the FTC does, and so is the Game Theorists video. So what exactly does the FTC do with regard to advertising, you might wonder?
What would you say you do here?
Congress has given the FTC the authority to civilly enforce the laws concerning false advertising. Again, the FTC does not do criminal prosecution. That's the Department of Justice. The FTC, which is in the Department of Commerce, does civil lawsuits as well as internal agency proceedings. The federal law authorizing this is in Title 15 of the United States Code at Section 45. It says that the FTC is empowered and directed to prevent unfair or deceptive acts involving commerce. Side note, the definition of commerce in this act is interstate commerce because under the U.S. Constitution, the federal government does not have authority over commerce that is completely contained within the borders of the states. State governments, of course, do have authority over that, and we will briefly discuss state enforcement in a bit. The law goes on to say that whenever the FTC finds or suspects deceptive trade practices, such as deceptive advertising, they can hold a hearing. Whoever is accused of doing the deceptive practice has the right to show up and defend themselves. If the FTC determines that deceptive advertising has in fact occurred, the FTC can enter an order forcing the wrongdoer to cease and desist from the unlawful trade practice. That means they have to stop it. What if they don't stop it? Well, down here under the section that says penalties, Congress has written that if the FTC has made an order to stop doing a deceptive practice, and if that order is violated, a civil penalty, i.e. fine, applies for up to $10,000 per violation. And if you don't pay, the government can sue you for the money in federal court. The FTC also has the power under Title 15, Section 53 of the United States Code to file a civil lawsuit in federal court to enjoin an act or practice that is in violation of any provision of law enforced by the FTC. In English, that means the FTC can sue someone to get a court order saying stop doing that deceptive trade practice. Now, I said a minute ago that the FTC has the power to have their own hearings and issue their own stop doing that orders. So you might be wondering, what is the difference between a stop doing that proceeding in the FTC and a stop doing that proceeding in federal court? Good question. Either route is eventually going to end up in court if the case is contentious enough, so it just kind of depends which route is used. Let's say you're an advertiser and the FTC sends you a summons saying, hey, we think you've been making deceptive ads, so you need to come in and have a hearing in the FTC about this. And let's say you have that hearing and the FTC rules against you, finding that you have been engaging in deceptive advertising. They will issue an order saying you have been doing illegal advertising and now you have to stop it. If you disagree with the FTC, you have a right to appeal their findings and their order in federal court. And in that case, you would file a civil action in probably US District Court, and you would be, in a manner of speaking, suing the FTC. The court would then decide who is right. So that's the first route, the route that starts with agency proceedings and then might move to court. There is another route that the FTC can take. Let's say you are an advertiser and the FTC thinks you're engaging in illegal advertising. They can skip the agency hearing if they want to, and they can instead sue you in federal court right away. And then the court would decide who is right. So you see, it can end up in the same place. I'm not an expert on FTC practices, but based on my general knowledge and experience, I would say that the cases where the FTC skips the agency hearing and goes straight to federal court would only be special cases, like big cases, and those where the FTC believes that the matter will inevitably end up in court anyway and justice should not be delayed. Like maybe it's a huge company that's done something very bad, or maybe it's a company that has a history of ignoring orders from the FTC. They might then decide to go straight to court instead of handling it inside the agency in a hearing. Smaller cases, first offenses, small advertisers, probably going to be sufficient to just summon them to the FTC for a hearing, which is a much more expedient and economical proceeding than civil action in federal court. Civil action in federal court takes years to resolve and usually thousands upon thousands of dollars in attorney fees. An FTC hearing can probably be resolved within, I'm guessing, 6 months or so, and it's less formal, much shorter, far less work required from your lawyers, which means lower attorney fees. So that is one thing the FTC does with their trade regulation power, reviewing cases of deceptive advertising and going to court in civil actions when necessary. The FTC also comes out with policy statements which clarify their position on rules of advertising and trade. They publish these and you can find them on their website. One example of a policy statement is this one, which clarifies the meaning of deception in advertising. It says that an advertisement is deceptive if it contains a misrepresentation or omission that is likely to mislead consumers acting reasonably under the circumstances to their detriment. Although deceptive claims are actionable only if they are material to consumers' decisions to buy or use the product, the Commission need not prove actual injury to consumers. In English, that means, in order to conclude that an advertisement is deceptive under the law, number one, there needs to be a lie in the ad. Number two, the lie in the ad needs to be about something important enough to make the difference between a person taking the product or not taking the product. Number three, the lie in the ad needs to be believable enough to convince a typical person. Number four, something detrimental needs to happen as a result of customers believing the lie in the ad. For example, if the ad was for a mobile game and it contained a lie about how the game is played, and then I download it only to find out it's a whole different game, that's detrimental. Because I go, aw. One more part of that policy statement, actually. Number five, the FTC can take action against a deceptive advertiser whether or not there is evidence yet that the advertisement has actually harmed anyone. The FTC also does something called advisory opinions, which are similar to policy statements, but they are done in response to questions. If you should ever have a question about whether or not your advertisement is something the FTC would approve of, you can write to them, or you can search their past advisory opinions to see if they have already addressed a question similar to yours. I searched on there, but I was unable to find any advisory opinions concerning games or downloads. However, there is an article on the FTC website in the General Tips and Advice section that discusses the rules for product demonstrations in ads. It says that when an advertisement shows a demonstration of a product in action, The visual must be a truthful representation of what the product can do. In 2014, the FTC called onto the carpet Nissan, the car company, and their ad agency TBWA, which is a big Madison Avenue agency. They had put out a commercial that shows a Nissan Frontier pickup truck pushing a dune buggy up a steep sand dune. As it turns out, that stunt was faked. And in the first 3 seconds of the ad, there was text on the screen that says, "Fictionalization, do not attempt." Nonetheless, the FTC found the ad misleading, regardless of the quick disclaimer at the beginning. In their written decision on the case, the FTC said that putting the ambiguous term fictionalization on the screen for a few seconds does not sufficiently undo the misimpression that people are watching a real Nissan pickup in action. This case, to my knowledge, was settled at the FTC level and did not go to federal court. Nissan and the FTC came to a settlement agreement. Nissan agreed to not run ads that misrepresent the qualities or features of their pickup trucks through the depiction of tests, experiments, or demonstrations. And that was pretty much it. There was nothing in the FTC records about a fine or anything. This is apparently how it goes for first offenses. Of course, if any person actually bought a Nissan Frontier truck based on their belief that it could push a dune buggy up a steep sand dune from watching the commercial, they could sue Nissan privately for consumer fraud and try to use the FTC records as proof that the ad was misleading. What does that have to do with video games? Video game ads show demonstrations of gameplay. In fact, that's what kicked off this whole episode of Habeas Humor, which I was trying to keep on the shorter side, and now look at me. But about the video games, you guys get the point, right? If we, the masses, get shown a game ad on our mobile device, and the ad shows footage of what looks like a video game, we would be reasonable in assuming that the footage being shown is footage from the game being advertised. If it turns out that the game footage is from a different game than the one being advertised, that is a misleading demonstration of the game, and therefore the ad is violating the federal truth in advertising law. If the FTC was to learn about this, say through complaints by multiple consumers, it sure does seem likely that they would agree with the complaints. That would be consistent with the FTC policy statement about demonstrations and their findings in the past, such as with the case of the Nissan truck ad and the sand dune. So has the FTC done anything about misleading mobile game advertisements? And if not, why not? Let's see what the game theorists say.
Given that people who download a mobile game based on a misleading ad aren't experiencing negative health outcomes, and in most cases aren't even spending any money to install this free app, the FTC likely has much bigger fish to fry. Say for instance, products with false claims around preventing disease. A complaint saying, hey, I caught a highly contagious virus because this mask didn't comply with the filtration standards that the advertiser claimed. Probably gonna rank a lot higher than, hey, I spent 5 minutes installing this mobile app and it wasn't like what the ad showed me. If you look through the complaints about misleading ads that have led to actual FTC action, they all have one thing in common: the fact that these misleading ads get people to spend money on something that was either a fake product or not what it claimed to be. However, these misleading mobile game ads seem to fall short of that. It's true, mobile games do have in-app purchases, but odds are that by the time you start paying money for imaginary currency in that Match 3 game, you're already past the point of realizing, hey, wait a minute, this isn't the game that I saw in the ads. The misleading ad isn't trying to get you to pay money, it's simply trying to get you to install a free app, which will then go on to try and sell you in-game items.
The game theorists essentially say here that the FTC has not cracked down on mobile game ads that have fake visual representations. And the reason is probably not a lack of complaints, but rather the FTC not wanting to spend resources on this, since downloading free games does not directly cost the consumer any money or affect their health. So this would be a very low priority matter. That, however, appears to be a mere assumption by the game theorists, since they probably don't know any better than I do how many people have actually complained to the FTC about deceptive mobile game ads. Unless someone at the game theorists is actually working for the FTC, and I doubt it, they don't know the number of complaints or the thinking process of the commissioners at the FTC. But let's back up the trolley just a little bit. Is it true that the FTC has not taken any action against game advertisers that show false demonstrations of gameplay? I cannot say with 100% certainty, but based on my research, it appears to be the case that the FTC has not taken any action with regard to misleading mobile game ads or game ads at all. However, as the game theorists briefly mentioned, the FTC has taken action with regard to other mobile game issues, specifically those that involve money changing hands. Have you ever played a game where you ran out of points or lives or whatever, and the game says you can get more by completing an offer or survey or something like that on a third-party site? Have you ever gone and completed that survey or watched the ad or bought the thing, whatever it was, but then the game failed to give you the reward? If that has happened to you, then you are far from alone. In fact, the FTC just resolved a few months ago a case against a company called Tapjoy. Tapjoy does not actually make games. They are an advertising intermediary. They designed a platform that allows people playing mobile game apps to interact with third-party advertisers and gain rewards, such as virtual currency for completing tasks. In some cases, consumers pay real money and/or divulge personal information to earn the rewards. But in the case of Tapjoy, apparently all did not go well, and the FTC charged Tapjoy with failing to deliver the promised rewards. Also, failing to respond to consumer complaints, which numbered in the hundreds of thousands. Just like with the Nissan case, the FTC settled this matter and issued an order directing Tapjoy to do things such as stop misleading users about receiving rewards, ensure that its third-party advertisers provide any rewards that have been promised. They also have to properly act on consumer complaints. Once again, no fines are involved, and it appears this is the norm for first offenses. Coming back to the issue of mobile game ads with false gameplay footage. We heard the game theorists claim that the FTC has not done much of anything about it because the games are free to install. Therefore, consumers are not losing money over it. Therefore, it's not a priority for the FTC. The game theorists even point out a contrasting FTC case involving a company called Gesta.
When you look at the mobile game apps that the FTC has gone after, it usually involves ads that make false claims like, your phone has a virus, tap here to remove it. This was the case for an ad that targeted millions of Android users. The product, as it turned out, was not in fact a virus scanner, but actually a ringtone bundle that billed users for $9.99 a month. And Gesta, the company selling those ringtones, was required to give automatic refunds to people who were lured in by the false advertising.
So this Gesta matter was taken super seriously by the FTC. They ordered Gesta to make full, timely refunds to all customers who unwittingly paid for these ringtones. Plus, there was even, gasp, an actual fine imposed by the FTC. Gesta had to pay, in addition to the refunds, a fine directly to the FTC in the amount of $1.2 million. The FTC acknowledges that there was harm done over and above the money taken from people. They must be acknowledging that if they ordered Gesta to pay a punitive fine in addition to making the refunds, because having to pay a fine means that the refunds do not fully make up for the wrong. People who pull scams still need to be brought to justice even if they do leave customers' wallets intact. Consider the Donald Trump donation scam that was recently in the news. Trump was doing recurring automatic charges to people's credit cards when they made what they thought was a one-time donation through his website. If and when people called to complain, they got their money refunded. But what about the people who never noticed, or the people who just wrote it off because they didn't want to be bothered with the refund process? Trump kept that money. Even the money that got refunded was held by Trump as the equivalent of an interest-free loan. He got those benefits, plus, as always, he got the emboldenment to go ahead and pull the next scam because he has so far escaped any serious punishment for anything. The victims, on the other hand, lost more than money. They lost time they will not get back, and they suffered aggravation. The game theorists may have stated it correctly that the FTC is letting fake game ads slide because the games are free, but that doesn't make it right. I do hope that the FTC will take action in the near future. Just because a game like Homescapes is free does not mean that there is no harm done by their ads, if the ads are misleading. For one thing, We might be paying in other ways, such as lost privacy if the game downloads come with stuff like advertising cookies or other spyware. There is also the fact that by convincing you to download a game like Homescapes, the game company is wedging their foot in the door as a first step to persuading you, the customer, to pay them for in-app purchases. Also, just like with Donald Trump, these game advertisers get emboldened to pull scam after scam as long as they are not facing consequences. So, the FTC should act. And to help make that happen, we all should file complaints about those fake game ads we get. How do you file a complaint? Easy. Click the link in the description and it will take you to the interactive form on the FTC website. The game theorists do correctly state that the game ads we have been discussing are misleading. The part where they talk about FTC policy is slightly off. As we have discussed at length, it is actually federal statutory law, not FTC agency regulations, that prohibit misleading advertisements. The FTC has authority to civilly enforce the law, and the Department of Justice can prosecute people criminally. Speaking of prosecution, just in case you didn't know, prosecution and persecution are two different words meaning very different things. Sometimes people confuse these two words. For example,
there's an old saying about how it's not illegal if you don't get caught. And while that is certainly not true, there is a lot of truth to the claim that a crime that doesn't get persecuted might as well not be a crime.
Yikes, they used the wrong word. I don't want to beat them up about it, but I would certainly be remiss in my legal review if I failed to point that out. I'm sure that the game theorists have already been made well aware of that mistake through their comments section. The last thing to address in the game theorists video is this.
Thanks for watching! Also, as a quick addendum here, late in 2020, Homescapes and Gardenscapes, two of the games most synonymous with that pull the key style of advertisement, they got banned in the UK for exactly what we're talking about today, misleading ads. And now the ads have to include disclaimers like not all images represent actual gameplay, so not a big change, but baby steps, I guess?
I am glad that they pointed out this case with Homescapes and Gardenscapes. Both are made by a company called Theorists. The game theorists got the details of this a bit confused, however. First they say Homescapes and Gardenscapes were banned in the UK, and then they say the UK government required the ads for these games to have disclaimers for any footage shown that's not from the actual game. So were the games banned or not? According to the BBC, the games themselves were not banned, so points off for you there, game theorists. It was the misleading ads for the games that were banned. The Advertising Standards Authority in the UK received complaints from people about these ads that were running on Facebook, and they were advertising Homescapes and Gardenscapes to look like multiple choice puzzles and pin-pulling puzzles, when the games in fact turn out to be just more swapping shapes and columns like Candy Crush. Similar to the case of the Nissan truck, the Homescapes ads and Gardenscapes ads did apparently have a brief warning at the bottom of the video saying not all images represent actual gameplay, but was that a sufficient disclaimer? The ASA said no. The ad is still misleading about what the game is, and therefore the ASA said this. The ads must not appear again in the form complained of. We told Playrix to ensure that their future advertising presents gameplay that is representative of the games advertised. Advertised? They say advertisements. It's weird. Sorry, Brits. So the games were not banned in the UK, nor was it deemed enough to add disclaimers to the ads for the games. The ASA said if Playrix wants to advertise their games in the UK, they need to use ads that show graphics representative of the actual games. C- for that last part of your video, game theorists. To wrap things up, I'm going to briefly mention a few things that the game theorists did not bring into their video. I mean, obviously, they can't discuss everything, so I'm not holding that against them. And for me as well, I do mean I'm going to briefly talk about this because the episode has to end at some point. The game theorists talked about federal advertising rules and the enforcement authority of the FTC, but they didn't talk about advertising laws in the individual states. There are advertising laws at the state level and sometimes even at the city level, and anyone who runs afoul of these laws by falsely advertising in that geographical area is subject to being charged by the local prosecutors, or subject to being sued in state court. California Business and Professional Code, Section 17500, prohibits dissemination of information about products or services that is untrue or misleading and provides for both civil and criminal enforcement. New York State General Business Law Article 22A says deceptive acts or practices in the conduct of any business, trade, or commerce, or in the furnishing of any service in the state are hereby declared unlawful, and so is false advertising in the conduct of any business, trade, or commerce, or in the furnishing of any service. New York City Administrative Code Section 20-700 prohibits deceptive or unconscionable trade practices, and the city has used that law to bring fraud cases in court. For one example, there was a company called Better Homes that was handing out flyers in the subway stations advertising homes for sale. It turned out that these were shit properties offered at inflated prices, and in order to keep people from catching on, the company would discourage buyers from finding their own real estate attorneys, and the company would instead refer buyers to attorneys that the company was in cahoots with. The New York City Department of Consumer Affairs successfully sued Better Homes for fines and a court order prohibiting any future deceptive practices. Those are some examples of state and local laws against false advertising. Additionally, consumers who have been harmed by deceptive advertisements can sue in court. Most every state has consumer protection laws that say merchants have to pay damages, sometimes double and triple, if they make sales based on deceptive advertising. There is also a famous federal law in the U.S. Code called the Lanham Act. One application of the Lanham Act is trademark enforcement, but the Act also says people are entitled to sue for money if they are victimized by false advertising that misrepresents the nature, characteristics, qualities, or geographic origin of goods or services. This is in Title 15 of the United States Code at Section 1125. In addition to suing, customers can also report false advertising to certain non-government organizations such as the Better Business Bureau, which rates businesses and logs customer complaints. The Better Business Bureau also has a list of its own recommended advertising codes. Businesses generally like to avoid a bad rating with the BBB, so if you have ever had a bad experience with a business and they are unwilling to make good, I encourage you to file a complaint. Additionally, certain industries have their own self-regulation agencies, and although participation is voluntary, a lot of companies do participate. Two such bodies are actually part of the Better Business Bureau. The first is called the National Advertising Division. They review advertising based on challenges from businesses, complaints from consumers, or on their own initiative, and they make decisions about whether certain ads are okay or not. According to the website, their decisions represent the single largest body of advertising decisions in the United States. Another advertisement monitoring body in the Better Business Bureau is the Children's Advertising Review Unit. That name is pretty self-explanatory. The CARU monitors advertising that is targeted at children, and they seek change through the voluntary cooperation of companies. When relevant, they also seek enforcement action. Outside of the Better Business Bureau, there is an organization that oversees video games. It is called the Entertainment Software Rating Board, or ESRB. This is where game ratings come from. The ESRB has on their website a list of the industry-adopted principles and guidelines for responsible advertising practices. Publishers of games that come in a physical box and have an ESRB rating are contractually required to adhere to those advertising rules. The ESRB has an Advertising Review Council which monitors industry compliance. If a game publisher is found to have inappropriately labeled or advertised a product, the ESRB can impose sanctions such as monetary fines. In most cases, organizations such as the ESRB rely on voluntary compliance and they don't wield the power of the state, but businesses often will cooperate because they want to avoid litigation or bad PR. Furthermore, the FTC has said that if an industry self-regulating agency has a case where a marketer is refusing to participate in dispute resolution, the agency can refer that case to the FTC, and the FTC will investigate. So there you go. File those complaints, y'all. Wasn't there some large group of individuals that were super concerned about ethics in gaming media? 4chan, wherever you are, your time is now. Let's clean up this mobile gaming ad mess. Follow the links in the show notes about where to send your complaints, and if you really want to send a message to the sleazy mobile game industry, click the thumbs up button below. Raise the profile of this video, that'll show them.
Audience participation, playing along at home.
It is time for everyone's favorite segment, audience participation. This is where I ask you, the audience, a question and you send in your answers. On the last show, we talked about pink pillars. These are media influencers, usually women, that push misogynist ideas onto a female audience. I asked for your thoughts on famous pink pillars, particularly which one you most love to hate. The featured response is from longtime friend of the show, Laura Von Braun-Stewart, who says the best worst pink pill is Phyllis Schlafly, and the worst pink pill is Caitlin Bennett. This is very astute. Phyllis Schlafly was an evil sea hag who probably cost us all the Equal Rights Amendment, and even when she was practically a walking corpse, she showed up to stump for Trump. May she rest in hell. But she was smart and well-educated and ultra-effective. She was charismatic enough to amass a huge following. The polar opposite of Caitlin Bennett, whose name you won't even recognize unless you closely follow right-wing losers. As much as I cannot stand her and would never want to hang out with her in a social setting, I'm kind of dying to have an on-camera confrontation. I live 5 miles from Kent State University, where Caitlin Bennett pulled her famous armed graduation stunt. I have been patiently waiting for the pandemic to be over so that I can go walk around the campus and hopefully run into her when she's doing one of her ridiculous person on the street interview tapings. Here she is, walking around in a Pocahontas costume and basically telling people, "I don't think this is offensive. Change my mind." Weird how she did not ask a single Seneca or Cayuga person that question, at least not that we see. I bet they would have been able to give a much better answer than some randomly selected college students on the streets of Ohio. Of course, you won't usually find Seneca or Cayuga people in this area anymore because they were forcibly removed from their homeland and sent to Oklahoma, where the descendants of those who survived the death marches now reside. But sure, if you think some of the indigenous fashion was cute, why don't you take that too, Caitlin? Or in your case, the $10 plastic Halloween Superstore version imported from Taiwan because ya basic. The audience participation question for this show is, what online ad are you most sick of watching? Or if there is an ad you really love watching, what is that? Compose your thoughts in a social media post, share the link to this episode if you remember, tag Habeas Humor, hashtag it HHAP, alternately, post your answer in the comment section below if you're watching on YouTube. I will present my favorite response on the next show.
It's time to thank our awesome patrons. Without you, this show wouldn't make me so proud.
This show is made possible by the contributions of generous and wonderful viewers like you. I do work hard to make Habeas Humor, and if you are able to send a small monetary token of support via Patreon or buymeacoffee.com, I will be eternally grateful. The links are right at the top of the show description. Every new patron gets a personal on-air thank you upon pledging. If you pledge $5 or more per episode, you get a shout out on every show, plus a jarrone. What's a jarrone? Why, it is a handy 2-ounce glass jar with the show logo on it. I won't tell you what to use it for, but I will tell you that it is TSA compliant, and many an alcoholic beverage has entered and left mine. Please make sure I have your current shipping address if I owe you a jarrone. The current hero humorists pledging $5 per episode are Phil S., It's a Me, and Leona F., aka my mom, and new hero humorist Alexandra T. Thank you guys. The Herculean humorists pledging $10 and up per show are Brian B. and top patron Dang Griffith. Thank you so much to all the patrons, and thank you to everyone watching or listening. I would be super grateful if you could help me out with growing the show's audience. The way to do that is to like, subscribe, and share. Also, give the show a 5-star rating on every podcast platform you can. Getting in front of people's eyes on YouTube is especially difficult. As you know, if you are watching on YouTube, the site wants your eyeballs, so it recommends videos you might like. The videos it recommends are those that other people like. So if people don't click like on my videos, they won't get recommended. Please therefore hit the like and subscribe buttons. HabeasHumor.com is your one-stop shop for watching, listening, supporting, communicating, or sending your friends. Check it out and follow us on the social media. As always, do not take any legal advice from this show. It is for entertainment only. Do not make a mistake and think that we have an attorney-client relationship, because that's not how it works. And believe me, that's a good thing. The show's description and podcast notes contain links to the sources used in this episode, as well as how to find Habeas Humor all over the interwebs. Until next time, please continue to shelter in place. Social distance, wear your PPE, get the COVID vaccine if you can, and stay legal, my friends.